No worries. So I thought we could start off this morning just quickly, maybe having a little bit of time for some feedback on those typing tasks. First, I'd like to ask you if you had anything on your mind that arose when you were typing, and then I'll go through a couple of things that I noticed as well. Does anybody have any questions or anything that was on their mind when they were doing those practice types?
I completely forgot how to actually start it when the witness is already halfway through a sentence when your own part begins.
Yes. So sorry, Monique, just because my computer was a little soft just then, I've just turned the volume up. Were you just saying that you forgot what to do when the witness has been examined and then they're interrupted halfway through, but they continue on with their thought? Was that what you just said?
That was going to be my second question. It was actually how to start your own cut when the witness is already halfway through his sentence when your time begins.
Yeah. No worries. That's a really good question. What I'm going to do is just share my screen with you and we can go over that now. That's perfect. Okay, so beautiful. So you should be able to see my screen now. I'm just going to get up a Word document and I'll show you. So there's a really easy answer to that question. Basically, it is you just type what you hear. So if it's halfway through a witness's response, that's actually fine. Say, for example, you were starting your cut up here and you'd gone, for example, and popped your footer in. Say you're doing cut J and the recorder was HC and it's KLM. And you've started your cut and they're halfway through their sentence. You literally just type what you hear. So for example, if they were saying, and that's why I did it, then you just type that, and that's why I did it. Something I would keep in mind is that generally at the start of our cut, we make sure that we're not starting with a capital if we're halfway through a sentence. But then after you've done that, you'd literally just pick up with the next question. So say the next question was the barrister saying, and what do you mean by that? That's fine. Then you continue on with their answer. Something that I would mention to you is that particularly with witness evidence, it is sometimes necessary to scroll back a little bit from where your cut starts, just to figure out whether or not you've had a change in speaker and thus whether or not you need to have a name in the inner margin. So for example, say you started up here and you were halfway through the sentence, you don't necessarily know who it is that's asking the questions at that point. You could assume that it's the lawyer, and 9 times out of 10 you would probably be right. But sometimes, for example, maybe the question that was asked that got this response was by the judge. And then perhaps the question directly after it was by the lawyer again. So that's what I mean when I say that sometimes you have to scroll back a little bit and just listen to what comes before your cut. You know, it may only be sort of 15 or 20 seconds, but that will tell you whether or not there's been a change of speaker. If His Honour asked the question that gave you this response up here that you've got half of, and then the lawyer came in next, then of course you would have to put in Mr. Lawyer in the margin to indicate that there's been a change in the questioner from the last question. But if you scrolled back and you listened to the question that garnered this response and it was the lawyer, and then the lawyer continues, then obviously we don't need to have any name here in the inner margin. Does that make sense to everybody?
Yes. Yes.
Perfect. Any questions about that? Not by the sounds of it at this stage. Okay, amazing. Monique, can we move on to your second question? I'm sorry I anticipated you before, but you mentioned it in your email, so I was raring to go with this one.
Yes,
Monique
yes.
also had yeah, perfect. Monique had a really excellent question about what happens when a witness is interrupted halfway through an answer. And I'd love to go over that now because it touches on some of the things, some of the oddities that we mentioned yesterday in terms of witness evidence. So say down here I have His Honour asking a question just for the sake of it, and he says, what do you mean by that? And the witness says, well, I was just telling you that, and then is interrupted. So we do our 3 dashes. And I have to say, you guys are all doing a fantastic job with the dashing in and dashing out. So great work. But he's interrupted by His Honour again, just saying, I want you to give me a firm response. So he's interrupted the witness. All that we do to continue the witness's response, if he continues directly on with what he was saying, is we pop another question and 3 dashes in for His Honour. We do a space. We type 3 more dashes in for the witness, and then we continue their thought. So up here he was saying, well, I was just telling you that I wasn't the murderer. And we finish his sentence there. So just to reiterate, His Honour asks a question. What do you mean by that? The witness starts to give an answer. Well, I was just telling you that. Oh, he's interrupted, so we dash him out. We then pop in His Honour's interruption. I want you to give me a firm response. We put that in the question, the Q&A format, even though it's a statement, not a question. And then we do the dash in for the witness to finish off his thought. Of course, we wouldn't need this dash if the witness didn't finish his first thought. If the witness, for example, had answered up here, well, I was just telling you that, but then is interrupted by His Honour saying, I want you to give me a firm response. And the witness says, yes, I will give you a firm response. Then obviously we don't need to dash him in here because he's not finishing off his first thought. This is the start of a new thought and it's in direct response to what His Honour has said here. Does that make sense to everybody?
Yes. It does, but in the one that I did, the lawyer asked a question, the witness started responding, and then the judge interrupted, and then the witness kept going with his original response to the lawyer. So I didn't know how to show that.
Yeah, I don't blame you. That's the worst when that happens. It just ends up looking a little bit messy, to be honest. So, for example, if His Honour were asking the question up here, the witness started responding, and then the lawyer came down here and said, I want you to give Honour a firm response. But the witness kept on going with what was happening up here. We basically just do what we spoke about before, but it's just weirdly in response to the new question, to indicate the fact that there has been a change in speaker. So here we would say, telling you that I wasn't the one who did it. Sometimes as well what happens is that His Honour and the lawyer might be talking together, and the witness will chime in just with his 2 cents. So we briefly touched on this yesterday, but I might just mention this again. In that case, say Honour said, what do you mean, Mr. Lawyer? Mr. Lawyer then says, well, I just meant that dash, 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 and is interrupted by the witness who is not responding to any sort of question. We would then pop witness in the margin. But I want to talk. So the only time that we pop witness in the margin is when they chime in with their 2 cents, and it's definitely not in response to a question at all. So there's a little bit, that's really the witness interrupting what's going on to say something, because we've also spoken about the fact that a lot of the time His Honour might be directing speech that isn't really a question to the witness, but it's still directed to the witness. So we do it in the Q&A format. This is a little bit different, where nothing is being directed to the witness. He just chimes in, and that's when we pop witness in the margin. Monique, does that answer your question? Or should we do another example? How are you feeling about that?
It does, yeah.
It does, perfect. You'll come across more examples of this as we go on, so hopefully you'll have lots of practice to type that, and it'll just become second nature to you, what seems quite weird at the moment. Perfect. Does they were great questions. Does anyone else have any questions about what they typed yesterday? Maybe things in terms of formatting or style or ambiguity in the manual. That's always another one. I think someone had a question about copyright, actually. Who was that?
It was me. I noticed that in the manual, it says you have to have it in the first turn of the first day, but there's no macro or anything, or I couldn't see one anyway to enter it. So I wasn't sure if I was meant to just copy and paste it from somewhere or what you do.
Well, look, that is very resourceful. When in doubt, you could totally do that, but you can actually find it in Microsoft Word. And that is such an excellent question because we didn't touch on the copyright at all yesterday. So great use of the manual there, Nicole. I'll just show you where it's to be found. It's actually in, if we come up to, so in Microsoft Word, in our VGRS Word macros, at the start of the day, so the first cut on the first day of the trial, we would pop in a little copyright blurb, I suppose you would call it. And because it's the first cut of the day, you actually find that little copyright in your footer. So if you come over to document and to start document, as we would if we were setting up a criminal footer, you can actually see that down here there's an insert copyright. Now, I sort of glossed over that yesterday, but that's where you can find it. So say I was, again, doing cut J, Hanan is my monitor, there are my initials, and I wanted to insert the copyright. I could do that. And then you can see there's a little copyright macro here. Now, I can probably show you what that looks like. Just give me 1 second. So I'm just going to come to a matter that sat a few months ago that we're going to be actually looking at a little bit later. And if we have a look at day 1 of the trial, here we go. We can see that the first page of the transcript, the very first cut, we have this little copyright blurb up here, the Crown and right of the state of Victoria, etc., etc. So that's what that little condensed macro looks like in full. And it is all taken care of in the merge in that way. Now, just on the copyright, it is so wonderful if, as a typist, you can remember to pop that in if you have the first cut on the first day. But it is not the end of the world if you forget, because part of our transcript coordinators process when they're doing the merge is to check that the copyright is in, is to check a whole raft of other things. So it's ideal if you can remember to pop it in, but don't let it keep you up at night if you forget every now and again, because the TC should pick it up in the merge as well. Anyone have any questions about the copyright? No? Perfect. And everyone's comfortable with where to find it? VGRS Word macros, where we go for the footer under document, start document, and then we just press the little insert copyright. Perfect. Now, Nicole would have seen that in the manual. And Monique and Diane, just in case you're interested, if you're really into the manual like I am, I can actually tell you where...
Actually, me, Diane, mentioned that before. It wasn't Nicole talking, it was me.
Oh, I'm so sorry, Diane.
I think the little bit of static might be coming from Nicole that makes it look like she's talking sometimes when she's not. That's what I was noticing. There's quite a bit of interference. Oh, no, don't apologise, but I think that's probably what happened. So I just thought in case you, sorry, I didn't, it doesn't even matter.
No, that is perfect. I would much prefer to know who I'm speaking to. So thank you very much for that, Diane. I think it's also my fault because I had my FTR in front of my little participants window. So I just must have seen that static. So thank you so much for that, Diane, for letting me know. Oh, yes. So in the manual, if you are interested, a section that I brought to your attention, I think maybe on the first day or perhaps even yesterday, was the section where it tells you what we type as transcriptionists for each different court or each different jurisdiction. That's a really, really handy part of the manual to have a grip on. So for memory, it is in section 6. So in section 6, you can see, if I just find it, So there's actually a section with a table for each of the courts that tells us exactly what we do and do not type as typists for that court. So you can see here on my screen that I have up the section in section 6 for what is transcribed in the county court, and that's on page 34, just in case you're keeping notes. And if we come down, we scroll down, we can see that the copyright is inserted on the first day of a hearing. There's an exception there for rulings, judgments and sentences, and that's good to keep in mind, but we won't go over that now. This is also really handy because you can see other things in here that we've already spoken about. So, for example, oh, actually, weirdly in the table they don't have discussion, but under discussion in the manual, it certainly tells us that all discussion is transcribed for the County Court and Supreme Court, and that's something that we spoke about yesterday. But you can see all sorts of other things in here. For example, opening addresses a little bit further down. So that's what we spoke about yesterday when the lawyers get up and introduce their cases, when the prosecution might speak for upwards of an hour and the defence usually speaks for about 15 minutes. We can actually see here that that's only typed as requested for the county court in criminal matters. We type all of the discussion, so all of the chit-chat that happens between the judge and the counsel, but those speeches given by the lawyers actually aren't typed by us. We use a macro instead to make known in the transcript that that is what has happened. So these are things that we'll go over a little bit more as we go on, but it's really good just to know about this section in the manual where the copyright is mentioned. And I think the copyright is also mentioned in section 7, but it's good to have a look at it here. And there's also one for the Supreme Court in section 6, which is just a little bit further onwards at page 50. Same table, just shows you what is and is not typed. So thank you for bringing up the copyright, Diane. That's really great. Any other general questions that you encountered or points that you encountered when you were typing yesterday? Not yet by the sounds of it. That is perfect. I thought I'd just mention a couple of really quick little things, and they're almost all just stylistic oddities of the VGRS manual. So the first thing that I just wanted to clarify is that, oh yeah, we have a section in the manual that lets us know what we should be capitalising and what we should not be capitalising. So I'll just pull it up for us. It's actually at page 66 of the manual. Actually, it starts on page 65 of the manual, sorry. And this is in section 7 again, our sort of Bible section of the manual. We can see down here at the bottom of page 65, it gives us a little list of nouns which are capitalised when they're number. So, for example, things like exhibit, which is something we're going to be speaking about this morning. If they're talking about what the accused person is charged with, say charge 6 will have a capital, and so on and so forth. So this little table of nouns, when in conjunction with a number, will be capitalised. A little further up, it gives us some more information just in general about what is capitalised. So, for example, we can see that lots of names of people involved in the court. So, for example, the tip staff and the associate, the judge's associate, both of those are without capital letters. In general, sir and ma'am are without capitals. Doctor is without capitals unless you're referring in speech to a specific doctor. So say a witness is on the stand and you say, thank you, doctor, you would capitalise it then. But otherwise, as we can see down here, just in general, were you the doctor who administered, it would be with a lowercase. We have a little blurb there on mum and dad, for example, as well. That's also good to have a little read of. In general, it's mum and dad with a lowercase, but if you're referring to someone as mum and you could replace it with a name, then you capitalise it. So you can see the little example down here. Did you accompany your mum? Just general, lowercase. Yes, I did go with mum. And we're using it there in a way in which we could replace it with Jane with an actual name, so we capitalise it. I remember my dad, just in general, lowercase, and Nan, couldn't replace it with the name, so we put a capital, came along with us. Likewise with drug names, we can see there that the proprietary names of drugs and other chemicals are capitalised, but generic names are presented in lowercase, and so on and so forth. And if we come on to page 66, we also see a big table there of nouns that we do not capitalise. But in general, as a rule of thumb, what I would say is, when in doubt, do not capitalise. Of course, Your Honour, we always capitalise the Y and the H, but other things, if you're not sure and you've had a read through the manual and you don't see an example that applies, I would tend towards not capitalising. That's capitals, pages 65 and 66 of the manual. I was also just going to mention something that might have come up yesterday when you were typing witness evidence, and that is that a lot of the time you'll notice that lawyers tend to have verbal tics. So, for example, if I jump back into my Word document, say I was typing witness evidence, and Mr. Lawyer asked a question, was given a response, and then goes to ask another question, but at the start of it says, all right. Or maybe he says, okay, yes, all right. Or maybe just says, okay. Or maybe just says, yes. These things, if they're not important to what the lawyer is going to say leading into the question, we can generally leave out for the sake of a clean and readable text. Now, this is particularly true when you have someone, say like Mr. Lawyer, who will say all right before every single question that they ask. So he might say, all right, and he asks another question and they give a response. And then the next question says, all right again. But what about that? Because a lot of lawyers, for example, will use okay or yes okay, and they'll say it every single time. Feel free to leave that out if it's not important to the sense of what comes next. Did you guys find when you were doing the typing task that you had a few of those sort of verbal tick all rights or yeses?
Yes,
I had a few in mind.
Okay, yeah, bit of a mixed bag there. It can be really irritating as a typist, especially when you're starting out. I find as I go on that I just tend to not really hear it anymore. But that's certainly something that you can leave out. Unfortunately, there isn't really a section in the manual that goes over that, but it's something that Kat, who obviously worked for VGRS for a very, very long time, has let us know as we've gone on. So that's that. Something else that I wanted to mention is what happens when they mention particular cases in the transcript. So you might have, when you were typing Lee, heard reference to, I believe it was the Crimes, Mental Impairment and Unfitness to be Tried Act. So obviously that has a title that lets us know that it is an act of Parliament, it's a piece of legislation. And I very briefly mentioned, it might have been on the first day, that there are actually places that we can find those acts, we can find that legislation, and we can find out exactly how to spell the names of the acts and exactly how to format it, because sometimes they might chuck in, for example, some cheeky brackets and things like that. So I just wanted to let you know about two websites in particular, or actually three websites. The first one is when you have legislation being referred to. Now, if you wanted to see a particular act and how it was spelled, you could just go to www.legislation.vic.gov.au, and you can see immediately it brings up everything that we need in order to access that legislation. So I generally would go into Victorian Law Today, and you can see here we can search by letter. So if I would have looked for crimes, mental impairments, and select acts. Oh, it's come up with nothing. That's awkward. Okay, well, it gives me a whole lot of them here, but then I could scroll through and find the Crimes Mental Impairment Act if I wanted. The other thing, of course, you can do with legislation is just Google it. And a lot of the time that will give you direct access to what it is, whatever it is that you're looking for. What do we do, however, if the judge or maybe the barristers are referring to particular cases within the text? Now, I think I mentioned Jade the other day, so I'm just going to get that up again. If you go to https://jade.io, you can search for cases here. So, for example, say I wanted to find, we can see down here there's Lane against the Queen. I could come up and type in Lane, and it gives me a whole bunch of cases with Lane in the matter title. Now, I find Jade really user-friendly because it gives me all of these options. The website I'm going to show you in a second, I find to be a little less user-friendly because it doesn't give you all of these sort of anticipated options. So you really have to know the name of the matter that you're looking for. Otherwise, it's a little bit difficult. But this is a really good way to find cases. I'll just show you that other website. It's called Ostly. And you can access it at www.ostly.edu.au. Very similar to Jade in that we come up here to search all databases and we can search Lane, for example. I think it was against the Queen. And it gives me a whole bunch of results here. But you can see that sometimes if you're looking for a case and you're not 100% sure what it might be, say the judge has mumbled the name, Jade can be really helpful there because you can have a look at all the options and see if any of them sound like the mumble that you've been given by the judge. Now that also leads us into how to cite cases or how to type cases in a text. I'm just going to draw your attention to the section in the manual that deals with this because it is fairly involved. And I think it's probably better for you to have a read through, and I'll just highlight the important points. So there's a section in the manual for case citations. Here we go. And it is on page 66, again, section 7. Now you can see here that it gives us an example of all of the different elements of a case citation. So, and excuse me if this is something you already know, but we have a case here. The matter name is R against Smith or Regina, the Queen, against Smith, so we know it's a criminal matter. And then what follows from the brackets onwards is what we refer to as the citation for the case. That is to say, the information that we need to know exactly which case it was, because as you can imagine, there are probably a trillion the Queen versus Smiths, you know, throughout the history of the courts in Victoria and the country and the world. So we have the matter name first, and it's followed by the citation that shows us exactly which matter it is. Now, if we had the judge and the barristers just generally referring to R and Smith or R against Smith, we don't need to worry about typing down the citation. We would just write R against Smith. Sometimes, for example, they might just refer to Smith. They might say, and of course, as we were discussing, in the case of Smith, well, in that case, all we need to pop in is the case of Smith. We don't need to worry about anything else. But every now and again, the lawyers and the judge will read out the full case name and citation. That's really handy for us as typists because it means we can immediately go to Jade and have a search in here for RV, for example. And we know exactly which one of these it's going to be because we have the citation as well. In that case, we would find exactly the case that they're talking about. We would come to our manual and we'd make sure that we were formatting it in the correct way. Now, these citations that I was just talking to you about, they are known as medium neutral citations, and they're the ones that we use in transcript. Now, it's not particularly important. Oh, just give me 1 second. I have a visitor in the office. Maybe I can introduce you. Everybody, just excuse me for a second. I have Ayla here, and I had to introduce you. Ayla is our senior transcriber and is just a gold mine of knowledge. She is also a transcript coordinator when she's not being a senior transcriber. So she does a lot of the merging that we've been talking about.
I just wanted to know if you had anything to send over to me that I can.
Oh, yeah, wonderful.
So, do you have anything?
Well, I've sent it all to Josie.
Okay. Cool.
At this stage, so I think that's fine. But if she wanted to handle
I think she's doing some other stuff. Cool, I'll get it from her.
You're the best. Thank you so much, Ayla.
Hi guys.
Thank you, everybody. Ayla is amazing, by the way. Just on that, if you ever have any questions, it's really great to have her on Spark because she knows the manual inside out, and she's got just years of excellent experience. But we were talking about medium neutral citations. So these citations here that we can see are known as medium neutral citations, and you can have a read about that in the manual. We just have to make sure that we are formatting it in that correct way that is specified in the manual. And usually that will correspond with whatever we find on JADE. So you can see here that the citations are formatted in a very similar way. Beautiful. Does anybody have any questions on that? Because I found when I started typing that that was a sort of strange thing to get my head around. How are we doing with that? No questions at this stage? No worries at all. Fantastic. So that's citations. Just remember, JADE and AustLII are fantastic resources for finding cases, and the Vic legislation that we spoke about before, or Google, are great places to find information on legislation or acts of Parliament. The next thing that I'd just like to really quickly touch on is just a point of clarification. Yesterday, you might remember that we spoke about different phases of witness evidence. And obviously you did some witness evidence typing yesterday. Now, you'll remember that for a criminal matter, our witness event macros are to be found under the VGRS word macros ribbon, and then under witness events. Now, I just want to clarify with you that these different phases of examination sometimes are referred to in short form. So, for example, down here, you can see these codes. Say I was to press, in any case, you can see under code we have an XN, we have an XXN, and we have a RE-XN. I just wanted to clarify with you that often in our logs, for example, prepared by the monitors, or elsewhere, perhaps on the spreadsheet, perhaps in the glossary, perhaps in the macros, we will use these short abbreviations to refer to different phases of examination. So as you might imagine, XN just stands for examination, and by that we mean examination in chief. So the first phase of examination that happens for a new witness. The XXN refers to cross-examination, so the second phase of witness evidence that occurs when the defence barrister will get up and ask questions. And the RE-XN refers to re-examination, when the prosecutor gets back up and says, actually, I have some follow-up questions after the cross-examination. I just wanted to make that really clear, because when you're looking at the logs, a lot of the time you'll see these short forms, and it can be easy to be sort of swimming in a sea of confusion about abbreviations when you're starting out. Perfect. So I think that's everything that I wanted to touch on in terms of brief feedback on issues that might have arisen yesterday in the practice types. I'd like to now move on to talking a little bit about exhibits. Is everybody happy with what we've discussed? There are no follow-up questions, no points of difficulty?
Those witness events, I completely forgot about them. Do we put them under the footer?
So don't worry about having forgotten about them, because I think actually in the type that you did yesterday, it was just one phase, and it was, I can't remember if you started when they were examined. I think you started when they were sworn in, sorry, I think you did. So the only witness event macro that you would have had to use yesterday would have been the sworn and examined one. So you can see here up the top, we know they've been sworn if they've made their promise on the Bible, and they say, I do swear to, etc., etc., etc. So it would just be a matter of clicking that one, popping in their full name, Joanne Finley Vlogs, their name into the witness abbreviated names, and then that comes up there as the macro. Every time there is a change of phase of examination, we need a new macro to reflect that in the transcript. So say the prosecutor finished all of his questions in the examination in chief, we would then come back up to the witness events when the defence barrister stands up to ask his questions, and we would click on cross-examination, and we would pop in the barrister's name. Then we can see here that a new phase of examination has started. Likewise, if he finishes all of his questions and the prosecutor gets up again to ask some follow-ups, we jump in again to witness events and we select re-examination and pop in the barrister's name. Then say the witness finished giving all of their evidence, there was no more questions from anybody, we would jump back into witness events and we would click the witness was excused and withdrew. Now it's important to remember that we can only use the witness excused macro if the judge has formally excused the witness. So if the judge has said, usually they say, thank you very much for coming to court, Mr. Vlogs, you are now excused. And they will then withdraw from the witness box. That's the point at which we would use witness excused / withdrew. However, say for example, we got halfway through the cross-examination and Mr. Defence Lawyer still had questions to ask, but it was lunchtime and they really had to go to lunch. What would happen is the witness would withdraw from the witness box, but we know that they're going to return after lunch. So they haven't been excused, they've just withdrawn temporarily. In that case, what would happen is we would come up to witness events and we would click on...
Just for a moment.
Yes,
I'm finding you're getting quite drowned out by all the interference today. I don't know if anyone else is hearing it, but I'm struggling to hear you at times. It's quite loud.
Oh, okay, I see. I'm just wondering if maybe we could figure out where the interference is coming from by muting. I know it's not coming from Monique because she's on mute today because she's a little under the weather and she's coughing and spluttering. Nicole, maybe do you mind just muting your mic briefly and we see if it might be
might be the air conditioner with the heater on that's making the interference.
Oh, okay, I see. Do you mind just briefly muting and we'll see if that's it? Okay. Possibly that was it because I'm not hearing any interference anymore. Diane, is that better for you?
Yeah, I can hear you perfectly. Sorry.
Okay. Oh, I apologise that we didn't work on this earlier. Nicole, as far as I understand, you should still be able to hear me. Perhaps the best thing to do, if you don't mind, is keeping your mic on mute. And then if you, for example, have a question or you want me to slow down or speed up or whatever the case may be, you can then unmute for that question or for that feedback. Is that okay with you? Feel free to unmute for a second to let me know.
Yeah, that's fine.
Okay,
Sorry,
perfect.
Nicole.
I'm sorry
I was just having a little bit of trouble hearing, so I'm sorry to bring it up.
No, not at all. It's much better to bring it up now because it's quite possible that Monique and maybe even Nicole might have been having trouble hearing. So that's really good. Thank you for that, Diane. Beautiful. So I'm just going to jump back into the example that we were just having a look at in terms of witness event macros. I was just explaining the difference between the witness was excused and the witness withdrew. Just remember the takeaway message is if the judge officially excuses the witness and then they leave the witness box, then we can use the witness excused macro. But if, for example, it's lunchtime and we've got to stop a phase of examination halfway through with the intent to resume after lunch, then we would just use the witness withdrew macro. we wouldn't use the excused one because they've still got more evidence to give. Now, another really important thing to keep in mind, given that we spoke a little bit about adjournments yesterday, so little breaks that the court takes, might be a temporary run, so a short adjournment, it might be a lunch break, it might be the end of day, is that before an adjournment, if we have a witness in the witness box, we must withdraw that witness before the adjournment. So really that's just a technical thing for us as typists, but I'll give you an example. Say halfway through the cross-examination, the judge decided that they wanted to have some discussion with the lawyers in the absence of the witness and the absence of the jury. What we would do in that case is we would withdraw the witness. Oh, actually, this is a bad example. Let me start again. Say in the middle of cross-examination, the judge decided that he had to go to the toilet. And for that to happen, he needs to have a short adjournment of the court. So the court needs to adjourn for, say, 10 minutes so he can go and use the loo. What would happen in that case is that we know that we would have to use the short adjournment macro. But we must keep in mind that if we have a witness in the witness box, they must be withdrawn using that withdrawn macro before any adjournment. So for example, we know that we're about to go on a short adjournment. His Honour's been talking, saying I need 10 minutes. We would come up here to the witness events macro. We would click on the witness withdrew. And then we would go to the short adjournment after that. So potentially here there might be just some discussion between His Honour and the lawyer, and that's all fine. Or perhaps he might say nothing, perhaps he might just immediately adjourn. But our adjournment macro would come after the witness has been withdrawn. And that's exactly the same for lunch. Even if no one says, oh, okay, witness, you can leave the witness box now, even if they're still standing in the witness box at the lunchtime break. In the transcript, we must have the witness withdrew before we have the break. Now, that's a very technical point. Does anyone have any questions on that? We can keep coming back to it, but any questions for now?
I don't.
Not by the, no, not by the sounds of it. Excuse me for letting that pause just linger, but I know because we're muting and unmuting, I just wanted to give it a little bit longer. Just remember as well, we can also go over this and over this in practice types. So it will become clear, no fear. And also there is a section on the witness withdrew in the manual, which I'll just point your attention to now. So in section 4 on page 18, we can see that there is a little section that reminds us about the difference between a witness being excused and a witness withdrawing. And I might leave it at that for now because the other things that we might talk about in terms of withdrawing versus excused will come up against as we go on. Beautiful. So thank you for the question about witness macros. That was a really good rehash because these are things that you kind of have to go over and over again because criminal courts are so fiddly in terms of the procedure for transcript. So that was a really good one. Wonderful. Now, as I said before, what we're going to do is we're going to move on to talking about exhibits because this is another concept that comes up a lot, usually in the midst of witness evidence, to be honest. So a lot of the time, what might happen is, for example, the prosecutor might be asking the witness questions, and as we go along, they might hand in evidence to the court, so pieces of evidence, say an object or a recording or something else that is relevant to what the witness is talking about during the witness's evidence. You can also have exhibits being tendered to the court at other points in the proceeding. So for example, during discussion between the judge and the lawyers, but a lot of the time it will happen during witness evidence. So a really good starting point to understanding exhibits and exactly what they mean is, again, the VGRS manual. You will find it at page 80. Excuse me, I can't spell exhibits. But at page 80 of the manual, Here we go. We can see that there's a whole section on what are exhibits, how to format them, when to use the macro, etc., etc. But in brief, an exhibit, as we can see here, is any document, photograph, or object introduced as evidence during a trial. And these need to be submitted to the court formally, and we call that process tendering exhibits. So a lot of the time you'll hear this word tendering or to tender during proceedings, and that means that they're going to be submitting a piece of evidence to the court for the court to keep and to keep on record. Now, there is a very specific way that we record the tendering of exhibits in transcript. And just on that, I'd really like if we could potentially follow along with some footage and have a look at what that process looks like in the transcript. Did everybody receive the email that I sent about downloading a bit of footage for the matter of Arnautovic this morning?
Yes, I did.
I downloaded it all.
Fantastic. So that was Diane and Monique were able to download?
Yes.
Oh, happy days. Amazing. Nicole, were you able to download it all this morning? It's fine if not.
I haven't yet, no.
Oh, that's okay. No worries. What I might do is, Diane and Monique, if you could perhaps just mute your microphones for, say, the next 10 minutes, so maybe to 11:25. You should also have the transcript that I sent along in a Word document this morning. So if you could go to, I think it was page 7 of the document, and to the place that I specified in the email at which the exhibits start. So I think from memory it was 2:27:50, and then the 4 minutes after that, and just have a little listen and watch and read through the transcript. And Nicole, if you could maybe just stay on here with me and we could have a little look through the transcript together without necessarily listening to the footage. Does that suit everybody?
Yeah, that's fine.
That's okay.
Yep, perfect, wonderful. So Diane and Monique, oh, actually, I've just remembered that yesterday you could still hear me when you were on mute and I was still chatting. So maybe, Nicole, what I might ask you to do is just to have a little look through the transcript that we sent through. If you're able to download the files now, then that's fantastic, but don't stress if not. I might give us until 11:30 just to give you a bit of a chance to potentially download the files, but don't stress too much if you can't. Just have a look at the transcript. And then once we come back at 11:30, we can talk about how to use the exhibit. Already, feel free to make your way back to Blue Jeans. And if you could let me know when you're here, that would be wonderful.
I'm back.
Fantastic.
I'm back as well.
Wonderful. Easy. Nicole, are you there as well? I think you were the third person who didn't speak before, if I'm reading my participants.
Yeah.
Okay. Beautiful. And were you able to get any of the footage?
No, my computer's really slow today.
No stress. Don't worry. When I started up this computer this morning, it just gave me a blank screen the first 3 tries, so I feel your pain. No problems. But you would have had a look at the transcript itself. And so you would have seen at page 7, we have some exhibits. So having just had a little look at that footage, you would have hopefully seen, first of all, the process of a witness being brought into the witness box, taking an affirmation. So that is the non-religious promise to the court that they absolutely will tell the truth. And then the first few questions of the examination in chief, or the first phase of examination, followed by the tendering of 2 exhibits, Exhibit A and Exhibit B, a little further down. Hopefully you can see that as well on my screen. This is also a really good one to have a little bit of a watch, because it's a very short first phase of examination, a very short examination in chief, and then we can see on the transcript that we immediately go into the cross-examination. And in fact, if you were being particularly eagle-eyed, you could see that the typist has made a mistake because in the cross-examination macro, we have cross-examined by Miss Blair. So there's no reason here to have Miss Blair's name in the margin. But that's just by the by. So in terms of this particular witness, this is also a good example of what expert witness evidence looks like. So Nicola Martinson is clearly some sort of scientist at the Victoria Police Forensic Science Centre and has been brought into this case, which is a drug case, to give evidence about the process of discovering what drugs the police were dealing with, exactly what quantity, and sometimes they also talk about the repercussions of certain sorts of drugs. So this is an expert witness that has been brought in for this case. Now, as we come down the page a little bit, we get to our exhibits, and we can see here we have our first exhibit macro, exhibit A, and a little bit further down, we then had our second exhibit macro, exhibit B. Now, as we've just spoken about before, exhibits are tangible pieces of evidence that are submitted or tendered to the court for the sake of the record. So we can see that exhibit A was an affidavit of the witness, and we have a date for that. Now, just in case you haven't come across the word affidavit before, an affidavit is a legal document that is signed as being true and correct by whoever it is who is giving it. So a lot of the time it's a statement that is given by a witness, for example. Sometimes it might be a statement that's given by a lawyer, and at the end they sign it, and they sign it to say that what I have said is absolutely true and correct. And if it turns out that it isn't, then I am liable to whatever punishment the law sees fit. Affidavit as a word just means, I think it's the giving of true words or the giving of a promise, and it obviously comes from the Latin. So that's another word that if you want to read up a little bit more, you can find a section for in section 7 of the manual under A for affidavit. So you can see here a couple of things in terms of formatting for exhibit macros. First of all, we've had up here the lawyer say formally, I tender that statement, Your Honour. Now, this is always going to be your clue as a typist that in a second you're going to be using a witness, rather an exhibit macro. We always include the lawyer saying, I tender that statement, Your Honour. And it takes all sorts of forms. They'll say, I tender that, I would like to tender that, I'm going to tender this, whatever the case may be, we put that statement in. What we don't put in is the judge's response and the judge saying, that will be exhibit A, the affidavit of Nicola Martinson dated, so on and so on. And this is something that you might have noticed when you were just watching that footage then. You can see that in the transcript we have the statement about the tendering, but they haven't actually included the judge saying, yes, that will be exhibit A, this is what it's going to be. Now, another formatting thing that we can see here is that in between that statement of tendering and the exhibit macro, we have one space. So there always needs to be a space between that statement or whatever comes last before we use the exhibit macro and the exhibit macro itself. Now, this is really good to note, but it's not something that we need to do. We don't necessarily need to press enter to make sure that there's a space because the macro is going to take care of that for us. When we are doing a macro, we pop our little cursor on the line under the last line of text, and we do the macro from there, and that should input the space. But it's really good to be aware of that formatting point because when we're checking our transcript, we want to make sure that the macro's done the right thing because every now and again you might have a glitch. Then down here we come to the macro proper. We can see that it has a little hash out the front, which is also taken care of by the macro button. It's called Exhibit A, and then we have the description of the exhibit, and we also have a date at the end here. Now, in terms of describing what the exhibit is, if the judge speaks a description of the exhibit, we put in almost exactly what the judge says, so the way that the judge describes it. So if the judge said, yes, Exhibit A will be the affidavit of N. Martinson dated 30th of the 5th, 17, we will put it in as the judge has spoken it. Sometimes, though, what you might find is that the lawyer will describe what the exhibit is, and then they'll say, and now I'd like to tender that, Your Honour. And then His Honour will say, okay, no worries, that'll be Exhibit A, and won't give any description of what Exhibit A is. In that case, it is acceptable to type the description as described by the lawyer a couple of lines previous. Of course, we need to make sure that it is readable. So if the description goes on for ages and ages, pick out the keywords most important to describing what it is and pop that in. If we have a date, it's very, very important for us to use this formatting. So we would just put dated, and then the date always has to be in this format. So 30th/05/17. And the reason that's so important is that in the merge, if we've popped it in a different way, it messes up our list of exhibits that we have at the end of the merged transcript. Now, all of those formatting things are mentioned in the manual, as I said, at page 80, but it's really good, I think, just to go through them together so we have an understanding of what it looks like. The other thing to remember is that every exhibit is finished with a full stop. Beautiful. So that's that. And once the macro's gone in, we can see that we can just start on the very next line underneath with the next question. And you can see here that before the exhibit, we had the lawyer speaking. So the lawyer saying, I tendered that statement, Your Honour. And then after the exhibit has been tendered, we can see down here that the lawyer is again speaking. So there's no reason that we need to put the lawyer's name, you know, Mr. Lawyer, I think it's a Miss Lawyer in this case, in the margin, because it's just the same person who was speaking before. If His Honour, though, asked a question straight after the tendering of the exhibit, then we would, of course, pop the new speaker into the margin. But if it's the same above and below, don't worry about a name in the margin. If we scroll down a little bit, we come to Exhibit B and we can see exactly the same thing. So here we have the lawyer saying, thank you, Your Honour, I will tender those case file notes. We have one line, we have the exhibit macro, it's named Exhibit B, described as case file notes, and in this case, we don't unfortunately have a date, but we have finished it off with a full stop. And then you can see that Her Honour is speaking after that, so we have a name in the margin because it's a change from up here when it was the lawyer that was speaking. Now, one thing that I will just mention before we go on to how do we use the macro for exhibits is that you may have noticed when you were watching the footage and having a listen that actually there was something in here that we could have done with this exhibit. Because when Her Honour was giving a description of the exhibit, she actually said, Exhibit B will be the case file notes on the voir dire. Now that is specific legal terminology that we will actually discuss time permitting this afternoon, or perhaps even before lunch. But I flag it to you now because if in the manual you come to your page 80 on exhibits, and you scroll down a little bit, you can see there are lots of different types of exhibits where we might have to type something slightly different before the description. There is actually a section 7.89.7 on voir dire. So in this case, the judge has described it as evidence that is on the voir dire, which we'll talk about later. We can see here that in that case, we would know to put in brackets voir dire before the description. So ideally, what we should have in this exhibit is voir dire case file notes. And I just mentioned that now because it's really good when you're typing exhibits, especially at the start, to have your manual open with you, because even if you're not 100% sure what a voir dire is, it's really good to be able to look in that section at page 80 and see, oh, this is something that we do just like this. And as you can see, criminal courts are fiddly, so even the most seasoned of typists sometimes will miss something out like that. And it's not the end of the world, it's just ideal if we have it in there. Beautiful. So before I go on to showing you how to use the macro for exhibits, does anyone have any general questions about exhibits, how they appear in the text, what happened in that footage? Just having a look at my little participants list.
I don't have one about exhibits, but I did about when the witness is sworn in initially.
Oh, absolutely. Yes, let's talk about that. What's your question, Diane?
When the court officer or the tip staff or clerk or whoever sometimes asks them their name before they're sworn, I notice in the actual document that we're following reading, they haven't put that question in. But in the manual, when it shows before they're sworn, if it's His Honour or Her Honour asking it, they did put it in. And, you know, they put the margin entries for the person instead of setting it out with a witness answer. So is it meant to be put in if it's a court officer or not?
Yes, so that's a really, really great question. It gets a little bit fiddly. Generally, the procedure for swearing or affirming someone is the same every time, and almost always it will be the tip staff who takes the witness through that process. Now, just as an introduction, if it's the tip staff, the court officer who is saying, you know, what is your full name, you know, place your hand on the Bible or get ready to take the affirmation, exactly as you said, we don't need to type any of that discussion. That is all encompassed in this macro here, affirmed and examined or sworn and examined. So none of that chit chat needs to be transcribed. But as you say, sometimes His Honour or Her Honour might, for example, intervene. And for example, maybe they were giving their full name and His Honour said, oh, sorry, what's your full name? And I think that might be the sort of thing that you're referring to that's mentioned in the manual. In that case, yes, you absolutely could include that. But it can get a little bit messy because we can really only use the affirmed or sworn macro once in a page of text, ideally. So if it's interrupted with His Honour saying, sorry, what did you say your name was? Probably we wouldn't put it in, because then we'd have, you know, His Honour's interruption here, and then it's not really right to say that they then continue on with saying, yes, thank you, because probably what happened in actual fact was that they finished off being sworn in. So in that case, a lot of the time, the typist might make a judgment call. And if it's just His Honour, for example, double checking what a name is or whatever the case may be, it's not that important. And so they'd probably leave it out. But if it is something really important, like, for example, His Honour saying, excuse me, Mr. Tipstaff, you didn't swear them in correctly. I need you to do that again. That is absolutely something that we would include in the transcript. Does that answer your question? Is that what you were talking about, that difference?
It is. And in the manual at 4.2.3, where it's set out that they're asking those couple of questions and it's sort of saying to do it, does that mean, is that just for something different, or is that perhaps just not quite accurate? Or
that is a great question. 4.2.3, page 14. Let me just jump on that, just so I can make sure that I'm 100% answering you correctly. Sorry, and I'll just pop it up on the screen so everybody can see it. Here we go. So you're looking at the called macro, is that right? Just here?
Yes, well, under that heading, I wasn't sure if you actually set that little bit out before they're sworn and not just use the called macro, or it was just confused altogether with that bit.
Yes, don't worry about being confused about that. This is the called macro is actually something that we're in the process of getting clarification from VGRS on. And I haven't mentioned it up until now for that very reason. As you can see in the manual, it is ambiguous as to exactly what they mean. At the moment, I've written lengthy notes about this because every time that it comes up, I need to refer to them. At the moment, the called macro we use very specifically. So you can see in there that it says, where a witness is brought into court or appears via video link, all questions directed to the witness must be transcribed. If the questioning is reasonably lengthy, and this is the important bit, i.e. over 5 questions, we use the called macro. So this is before the witness is sworn in or affirmed. This most frequently happens when we have evidence via video link. Now, don't stress too much about remembering all of these ins and outs right now. I'm going to go through the answer to your question because it's such a good one, but it is very fiddly and it's quite specific. So you have your manual with a bit of a description, and we can keep going over this as we practice, as we go on. But in short, if, for example, someone is going to give evidence in the court via video link, that is, they're not physically in the court itself, they're being beamed into the court, and their image is appearing on a screen, then a lot of the time what will happen is before they're sworn in, they will appear on the video link in the call. So the judge, for example, can ask them, can you hear me? Can you see me? Are you ready to go? This is what's going to happen next. And then they'll withdraw. The jury will be brought in. They'll come back via video link and they'll be sworn in properly. So that little chat between the judge and the witness when they're appearing before they've been sworn in is when we use the called macro. And we use it when there's over 5 questions between, say, the judge and the witness. If that happens, we use the called macro and then we use Q&A response. So I'm just going to get my Word document up to demonstrate this because it is so fiddly. If, for example, they've appeared via video link and just say we've had a little bit of a listen through and we can see that it's going to be a lengthy questioning, maybe it's going to be 6 questions, for example, between His Honour and the witness, I would use the called macro. I would put in witness's name, Joe Anthony Bloggs. Bloggs down here in the short name because it's his surname. And then I would have His Honour, can you see me? The witness says yes. His Honour, what about hear me? Yes. What about see the lawyer? Yes. We're up to 3 questions at this stage. What about the tip staff? Yes. What about, I don't know, the jury? That wouldn't happen, but yes. We've got 1, 2, 3, 4, 5, and one more. Do you feel comfortable? Yes. So in this case, this is a little chit chat that has occurred before the witness has been sworn in. They've just been beamed in via video link for His Honour to say, is everything right? Is everything ready to go? But it's gone on for over 5 questions. So we've used the called macro. We've used the Q&A format. So that is the little question mark 3 dashes format. We use the Control L for. And then when they disappear from the video link, we would have to withdraw them. So we come up to witness events again. We'd click witness withdrew. They haven't been excused, they've just withdrawn temporarily. Okay, everything in the court carries on. Maybe His Honour has a little chat to Mr. Lawyer, whatever happens. And then a little bit later, when the jury is back in the court and they're ready for the witness to be sworn in, we would then, when the witness appears again, come back up to witness events, click on sworn and affirmed. Anthony Joe Bloggs goes in again, or Joe Anthony Bloggs, whatever his name is. And they're sworn in, and from there we have the Q&A format because we know, because we've used this macro, that we're going to be starting the first phase of examination. So just to clarify what we were looking at before, His Honour was having a little chat. I'll just bring it up. There we go. I mean, we can see here that after she's been affirmed and examined, Her Honour has something to say, but she's already been affirmed and examined, so that's fine. That can come below the macro. If we come a bit further up, we'll see what happens. No, she didn't come into court before that. This is the very first time that we've seen her. So we don't need to worry in a case like this about using the called macro. It's really more when people appear over the video link before they're officially sworn in or affirmed. Does that make sense at a basic level on this stage?
That makes perfect sense, especially when it's a remote witness or when it's over 6 questions. It was just that because the manual says when a witness is brought into court or appears via video link, and they say if it's those couple of questions, like, are you so-and-so, that's typed like that on the margin. That's why I wondered whether when the tip staff asked that exact same question, should it be put in? That was really, but the answer was no. So,
So I've given you an incredibly lengthy response to a very short question.
No.
But yeah, absolutely. What you've just said is completely right. I mean, when it's the tipstaff and it's part of that procedure of swearing them in or affirming them, we don't really need to put anything. Even if the tipstaff, for example, stumbled while he was doing the swearing, he was like, oh, I got that wrong. Actually, we'll start again. It's all part of that swearing in process, so we don't need to put that in. I guess the only other thing, just to clarify there, because we've been talking about what happens when, for example, they appear via video link, or even if, for example, we had a witness in the court and they called them up to the stand and asked them, you know, 5 or 6 questions about whether they're ready to go, and then they left the stand again to go to the toilet or something and came back and then were sworn in, we could still use this called format. So the macro followed by the Q&A. But then what happens, of course, when it's fewer than 5 questions? And I think that's what you were just talking about then. If, for example, someone appears via video link and His Honour just says, can you see me okay? And the witness says, yes, I can. Then we would have Miss followed by her surname in the margin. She says yes. And His Honour's like, okay, that's all I wanted to know. See you, oh, excuse me, see you soon. And then they disappear off the video link again. We actually don't need to use any macros at all. So if it's just one question there, they've appeared on the video link, His Honour said, can you see me okay? Witness says yes. That's all I wanted to know, see you soon, and they disappear again. You can see we've used no called macro. We have not used Q&A format. We've done margin His Honour, margin Miss Witness, margin His Honour, and we don't need to do any witness withdrew. It seems strange because for us as typists, if we're reading a transcript and suddenly a witness is just randomly speaking, it's weird that we don't have anything in there that says, oh, by the way, at this point they appeared on a screen. But that's just the convention. That's just how it happens.
No, that's perfect. Thank you for that.
No worries. Thank you so much for bringing that up. And again, everybody, don't stress. These are things that will become clearer with time, or indeed never become completely clear because the wording is ambiguous. But have no fear. Great. So now what I'd really like to do is just show you how to use the exhibit macro, if that's all right. So say, for example, Mr. Lawyer had been examining someone. Oh, too bad I can't spell. And he says, I would like to tender this briefcase of files, Your Honour. I'm just going to fix my format. Okay. We know, because he said, I would like to tender, that probably what's coming next is the exhibit macro. So say in this case, His Honour says, no worries, exhibit A will be this briefcase, will be a briefcase of files. And actually I might do a date in there. Dated 31st of the 5th, 17. His Honour says, no worries, exhibit A will be a briefcase of files dated the 31st of the 5th, 17. What we're going to do is come over to our VGRS Word macros, which we're all getting very familiar with at this stage. And we're going to come over to Exhibits and MFI. We're going to click on that icon. And you can see that it brings up a box that then prompts us for an abbreviated code and an exhibit description. Now, the code is almost always going to be a letter or a number or a combination of the two. So, for example, in this case, His Honour has said it's going to be Exhibit A, so we put an A in there. And the exhibit description that His Honour said was briefcase of files dated 31 of the 5th, 17. So we can see we've put the description in as you said it. We've got the dated, we've got the date in the appropriate format, so the DD/MM/YY. And then we, of course, have to end it with a full stop. We press OK. And you can see that it's automatically inputted that one line of space that we need between the last bit of speech and the exhibit. And we've then got our cursor on the very next line to continue. So say it was the lawyer who continued speaking after that. And the next question is witness is, etc., etc., etc. Now, every now and again, we might get an exhibit that isn't just A or B or something like that. For example, a lot of the time, if you have a whole bunch of exhibits in a case, what might happen is that they might label it, for example, P1, and usually that means exhibit 1 for the prosecution. Or they might label it D1, which generally means exhibit 1 for the defense. And sometimes judges just go completely off the rails and seem to make up the abbreviations that they use. So I don't know, it could be one that I see quite a lot is like I've seen M's, for example. I've seen combinations of letters that might stand for someone's name. So if it was Miss Witness, it could be, I don't know, MW1, if this particular witness was going to have a lot of exhibits associated with her. Just listen to what the judge says as to the abbreviated code, and then input the description as the judge says it. As we said before, though, sometimes the judge doesn't give an exhibit description. In that case, we have to sort of scroll up a little bit and see how the lawyer described it and input it as the lawyer said it.
The judge always give a code?
Ideally, that is an excellent question. 99% of the time, yes, because they really have to. Every now and again, what will happen is that they will forget. Now, sometimes this is something that's rectified later on in the proceeding. So sometimes the judge will forget to give, for example, the abbreviated code, and then maybe in someone else's cut down the line, they'll be like, oh yeah, by the way, we forgot to give that a code. This is actually going to be whatever the case may be. If as a typist that happens in your cut, what I generally do was I would put in anything in abbreviated code. So say A, and then I come down here, briefcase of files. Let's pretend it doesn't have a date this time, full stop. And the reason I fill out both boxes is because otherwise it won't let me generate the macro. I go okay. And then what I would do is I would take out the A manually and just leave it as nothing. And I'd have briefcase of files. What I would then do is I would come back over to my transcript schedule. I would jump into the matter spreadsheet for the matter that I'm working on. And I would put a note on the spreadsheet saying, say it was in cut J, His Honour forgets to name exhibit. And then I would probably put a timestamp in as well. So say that happened at 10:31:42. I would say 10:31:42. And I would probably even let the transcript coordinator know. For example, I'd come up here and I'd see that Lauren is the transcript coordinator, and I can check that on the transcript schedule. And I might just even spark her and say, hey, just letting you know, His Honour didn't name this exhibit. I've made a note on the spreadsheet. This might be something that comes up a little bit later. And then in the merge, hopefully they can rectify that. Does that make sense to everyone?
Thank you.
No worries. Yeah, perfect. The other thing, just while we're on exhibits, I'm just going to come back in here. I might get rid of that so no one gets confused. Once we've generated our exhibit, so say this one is exhibit A, I'll chuck in the date again. Once we've generated our exhibit, of course, as you can see me doing now, we can add to it manually. This is something good to keep in mind because when you're in the macro, it will only let you type so much in the description. Now, if at all possible, it's good to keep the description succinct and clear, but every now and again, His Honour might give quite a long description and all of the elements of what he says might be important. So if it doesn't let you type everything in there, just keep in mind you can, type the first few words, get out of there, and then come and change it manually in the document. So once we've generated our exhibit macro, the other thing I would immediately do as a typist is I would copy and paste, and I usually just do it from the hash next to exhibit, but you could highlight the whole thing if you wanted, and I would copy it. I would come over to my matter spreadsheet and say it was for this matter. I would jump into my glossary, And you may remember when we were looking yesterday and the day before at the glossary, we have an authority section for Acts of Parliament and for cases. We have a witnesses section, which is where we put each new phase of witness, which is perhaps something we didn't go over, but we can come back to that. There's also a section, if we keep scrolling down, for exhibits. Now, it's actually at the end of this one because there's so many, but what I would do is I would come up to this section and I would paste in my exhibit. And what I would do then is I would, in parentheses, afterwards type, say this is for day 1, I would type 1, and then I would type in the cut, so say it's cut J, when this occurred, and then I would pop my initials in as well. This is also really important because not only can we keep track of all the exhibits, it also draws our attention to the fact that an exhibit might not have been named by the judge. So if, for example, like we were talking about before, they didn't name it as anything in particular, we could just put exhibit, and at the end I'd probably put in a little note, His Honour forgot to name exhibit, note made in spreadsheet, or maybe even TC informed. I know that might be going overboard there, but personally I like to cover all of my bases just to make it easier for the TCs. So it's really important every time we have a new exhibit that we copy paste the macro into our glossary. And if I come down to the bottom of the page here where all of these exhibits are, you can see not many people have remembered to put the day, the cut and the initials, but you can see there we've got all of those exhibits that have come up during the matter. And there were obviously a lot of these. Any questions on that at this stage? Not by the sounds of it? Beautiful. Okay, well, if any occur, please don't hesitate. So that's really what I need to tell you about exhibits at this stage. As I said, it's a really great section in the manual, great in that it's quite comprehensive. So if I were coming to exhibits personally, I would always have that out next to me, just ready to refer to. What I'd like to do for the next 25 minutes is just go over a couple of other things that you might come up against, particularly when you're dealing with witnesses and witness evidence, but things that can come up just in general as well in the running of the transcript. So the first thing that I'd like to talk about, we actually very briefly touched on before, and that is what happens when, for example, evidence is given via video link, or what happens when evidence is recorded before a trial and then played in front of the jury during the trial. So two different sorts of things. The first one is very simple to explain. A lot of the time, witnesses might give evidence from what they refer to as a remote facility. Now, the remote facility is almost always just another room in the same court, but they refer to it as the remote facility. This is particularly used when the content of a case is quite intimate or personal, and it would be traumatic for the witness to have to give their evidence in a court, sitting in front of the judge, the lawyers, the jury, and also the accused person. So as you might imagine, a lot of the time witnesses give their evidence via video link if it's a sex case. So for example, if someone is giving evidence about an instance in which they were raped, they will almost always give their evidence from the remote facility via video link into the courtroom. The same goes for when it's a child witness. Almost always, if you have a child giving live witness during a trial, it will be from a remote facility. And sometimes in the remote facility, they will have a support person, or they might even have, and I saw this for the first time the other day, something like a service dog. So this is usually something that the judge and the jury can't see, but they have all of these sorts of things in the remote facility to make it as comfortable and non-traumatic for the witness as possible. Now, when something like this occurs, for us, there's actually not a great deal of difference in the way that we type it. we type witnesses giving evidence via video link exactly the same as we would type it as if they were in court. So there's no difference in terms of our typing. The only thing is that we might have to use the called macro, like we were saying before, because they might pop in via video link beforehand. You might have that more than 5 questions, and you might have to use the called macro, do the Q&A format, withdraw them, and then when they appear later, you'll have to use the sworn in macro. But we don't have any notation that says they are appearing via video link. Usually they'll talk about it, you know, the judge and the lawyers will talk about it. We don't need to pop that in any way. And in fact, as we were saying before, if they appear via video link, the judge asks them 2 questions and then they disappear. We don't use any macros at all. For all we know, you know, they could be in the courtroom because we're using their names in the margin, and we don't withdraw them or anything like that. So if somebody is giving live evidence, but just from another room, we type everything they say and we do it exactly as we would if they were in court at the time. Does anyone have any questions on that just for a start? Not by the sounds of things. Perfect. I might move on then to another sort of thing that can happen in terms of witness evidence. Sometimes during a trial, the jury might be played evidence that was recorded before the trial began. Now, this happens fairly frequently, particularly, for example, if it's a sex case involving a child victim. Almost always there will be a special hearing that is held before the trial. It's in a court with nobody except for the judge and the barristers and maybe a support person. And they'll ask the child victim or the child witness everything that needs to be asked in the absence of the jury, and they will film it. And then when the when the trial actually starts properly, what then happens is that that recorded evidence is played to the jury, and that just means that the child involved in the case does not have to be anywhere near the courtroom. They don't have to go through that traumatic experience of having to sit in the witness box or sit in a remote facility and go through the whole rigmarole of the trial. So that's why they do it that way. So they might play for the jury a child witness's evidence that has been recorded before the trial. The other thing that might happen is that they might play the recorded evidence of a police interview during the trial. Now, this is generally known as a VAIR interview, and actually it's something that came up in one of your practice types, in the John's practice type. I think it was mostly, I think perhaps both of you who did that practice type might have typed it as indistinct because it was really hard to hear what they were saying, but they were actually referring to the VAIR tape. And you can find information about this in the manual at page 123 in section 7. Now, a VAIR tape, or a VAIT tape, as they sometimes refer to it, is video and audio recorded evidence. That's just what that stands for. And generally, it's an interview that has been conducted by a police officer before the trial. And then when the trial starts, they bring it into court and they play it for the jury as evidence. Every now and again, you might have a different sort of thing that is played to the jury. For example, in some cases, usually not, in some cases, for example, in criminal, you might have CCTV footage. So you might have someone pleading not guilty to robbing a shop. And then they say, well, we're going to play this evidence to the jury of the CCTV camera footage showing you robbing the shop. That's another sort of thing that might be played to the jury. Now, the reason that I'm mentioning this to you is because it's very important for us as typists to remember that we do not type the contents of that recorded evidence. It's a very important distinction. If we have someone giving live evidence just from a remote facility, so they're giving evidence on the day of the trial, but they might just be in another room and appearing via video link, we do type everything that they say. However, if evidence is played during the trial that was pre-recorded before the trial began, we do not type the contents of that evidence. I'm going to show you what we do instead of typing it. It's very simple. Say, for example, Mr. Lawyer, Ed, I would now like to play the VAR tape for the benefit of the jury. So we know that they're going to be playing some pre-recorded evidence. And in this case, it's the VAR tape, which means that it is a pre-recorded police interview. What then happens is we come to the next line with our cursor. We tab in once. And in parentheses, we type recording played to court, full stop, close bracket. So this represents all of the evidence in that recording that is being played. So say they have a VAR tape that goes for an hour. That whole hour's worth of footage is encompassed in this little inner margin example recording played to court. Now, if I just come up here to court events, in here, no. There is actually a place where you can find this, what we call inner margin example in the macros, but it's actually under the transcript ribbon at the top of Microsoft Word. Now, you might remember me saying that in general, we use the transcript ribbon for civil matters, but it does also have some little macros in it that we can use for both. So if you just wanted to stick to just using the VGRS Word macros ribbon for criminal matters, then you could literally just manually type this in. So do one tab in and type in recording played to court. If you wanted to take the short option though, you could come into the transcript ribbon, come over here to this little camera, click on it. You can select what sort of media it is. So say this is a DVD, it's almost always a DVD, and it'll give us recording played to court there. Now, say for example, the VAR tape, the police interview, went for 2 hours. And after hour 1, he's on, has had enough, he's hungry, he wants to go to lunch. He might say, please stop the tape there. Let's go to lunch. And then at that stage, the jury will leave, we'll use the lunch adjournment macro, and then we'll come back in later and they'll resume playing the recording. It would just be exactly the same as before. We would use recording played to court when it picks up again. So we don't need to make any notes as to the fact that this is the same recording as before. People reading the transcript will get that from the context of what's being said between the judge and the lawyers. Now, if you want to know where to find this bit about recording played to court in the manual, I would really recommend going to page 115, showing of media. There we go. We can see in here at page 115, it tells us that when we have this pre-recorded evidence, we need to use this notation, one tab in, recording played to court, and it reminds us down here, do not transcribe what you hear being played to the court. Do not make that mistake. Generally as well, you'll be happy to know as at-home typists, sometimes we'll have pre-recorded evidence that goes for literally days. So I typed a really hideous case actually at the start of the year, which had hours and hours and hours of pre-recorded evidence. What will usually happen in that case is that after the evidence starts, the pre-recorded evidence starts, one of our in-office typists will keep an eye on that matter and let everybody know when the pre-recorded evidence is finished. The reason that we do this is because it means that at-home typists can move on to something else where they're actually going to make money from typing words. Because as you might imagine, if you have pre-recorded evidence that goes for say 16 hours or something, you're not going to be typing a lot of words over a few days. So I just wanted to reassure you that you as at-home typists should not get stuck with pre-recorded evidence. That's something that the TCs, when they've been alerted to it, will let an in-office typist take care of. The other thing that I just wanted to mention on this point is in the manual, there's actually a list of what we call inner margin examples. So here, I've just told you that recording played to court is an example of an inner margin example. Of an inner margin notation, excuse me. And what we mean by that is just generally something that is preceded by one tab in and then describes something in parentheses that's going on in the court. So if we come to inner margin examples in the manual, there we go, it is on page 85. And if I scroll down, you can see there's a lot of them. Recording played to court is in here. All of these are preceded by one tab in, which is not described in the section, so I would definitely make a note of that. This is a very, very important section because there's a lot of notation in here that doesn't necessarily get mentioned elsewhere in the manual, which is not ideal, I have to admit. That was a bit short-sighted of VGRS. I would really recommend that you have a look at the inner margin example section because there are other things in here that are very important. For example, we'll talk about this a little later on, but in the absence of the jury is going to become very important to us. This one is very important, recording malfunction with a timestamp from when it started to when it finished. To witness is something that we're about to talk about now, also very important. Witness demonstrates. These are all things that it's good to just get your head around a little bit as to the fact that they're in this inner margin example section, because a lot of the time they might then prompt you to go and look at other sections in the manual, or they might just remind you that an inner margin example is needed. Now I can see we've got about 12 minutes and there's still a couple of things I'd like to talk about. Does anyone have any questions about that huge swathe of information that I've just given you? Not by the sounds of it at this stage. Okay, no worries. I keep forgetting that I'm with very fast learners. I'll just remind you again, anything comes up, please email me, spark me, raise it after lunch. No worries. We're going through a lot of information now, just because there's a lot to get through. Fantastic. So we've just spoken about the difference then between people giving evidence on the day from a remote facility, which we do absolutely type, and evidence being played to the record that has been pre-recorded. In that case, we do not type it. We use the inner margin example, recording played to court. Okay. The next thing I'd like to just move on to is to witness. Now, this is something that is very important when we are typing witness evidence, and I didn't mention it yesterday. Say, for example, a new witness comes into the stand. I'm going to go into VGRS ribbon. I'm going to click on witness events. I'm going to swear them in because they've decided to take an oath. Joe Anthony Bloggs. Okay, and now the prosecutor is ready to start his questions. Now we remember when it's the first phase of evidence, the barrister's name is not mentioned in the macro, so I'm going to put his name down here, Mr. Lawyer. And he asks a question, do you remember giving evidence at the police station? Yep. And the witness says yes. And then His Honour decides to interrupt already. His Honour says, hang on, I thought you were going to ask about the evidence in the VAR tape. Clearly we can see here that His Honour is not speaking to the witness. His Honour is speaking to the lawyer. And in fact, after that, Mr. Lawyer is going to respond to His Honour and say, yes, that's right, I forgot. And from that point, he's going to go back to talking to the witness. He's going to say, do you remember giving evidence in the VAR tape? Then we're going to use our Control L because it's to the witness. And the witness says, oh, yeah, Yeah. Now, what I want to draw your attention to in this example is the fact that there's been a change here between talking to His Honour and then Mr. Lawyer talking to the witness. Now, how are we supposed to know that there's been that change? I mean, we could get it from context because we can see that after this question, we're using the Q&A format again and the witness has given a response. But the lawyer hasn't used the witness's name. He hasn't said to His Honour, oh, yes, that's right, I forgot, and then gone on and said, oh, so Mr. Bloggs, do you remember giving evidence in the VAR tape? So it means that in the transcript, it's a little bit ambiguous. Is he still talking to the judge? Is he talking to the witness? What we do to clear this up is before the question to the witness, we would type in brackets, to witness, end brackets, and then we start off with the question after that, still with the capital letter for the start of the question. And we just remember that when we're using to witness, it's very important that we only use it when it's really necessary. So we never use to witness, for example, at the start. So for example, if His Honour interrupted and said, hang on, I thought you were going to ask about the evidence in the VAR tape, and the lawyer didn't respond to His Honour, just went straight back to asking questions of the witness, we don't need to have to witness in here because he hasn't had an exchange with His Honour. We will just leave it as, do you remember giving evidence in the VAR tape, and then the response from the witness. So it's really only when the lawyer has been speaking to His Honour and then in the same sort of lines of speech goes on to speak to the witness again and doesn't use his name to signify the fact he's doing that. If we had him speaking to His Honour, yes, that's right, I forgot, and then went on to say, so, Mr. Bloggs, do you remember giving the evidence in the VAR tape? There's no need here to put to witness at this point because he's using his name, it's perfectly clear. Any questions on using to witness at this stage? No, that's an easy one, no worries. Again, this is something that you can find in the manual, and excuse me for sounding like a broken record every time, but I really do want to give you these inroads into the manual. To witness can be found in the inner margin examples section, but also on page 17, 4.2.18, to witness, it describes how to use it for us. So just in case you forget, there it is. Beautiful. I've got 6 minutes, so I'm just going to see if I can squeeze in another little bit that I wanted to. Before we were talking about, sorry, that was just Josie getting in touch via Spark, and I might just respond to her. Perfect. Before we were talking about particularly sensitive cases, for example, sex matters. So, you know, we might have charges for rape or for incest or very sensitive matters like this. What will often happen in that case is when the victim, so usually in criminal cases, they're called the complainant, the person making the complaint against someone else. When the complainant comes in to give evidence in court, usually, as we said, it's via video link. But what will often happen is that they will close the court. Now, you might remember actually that in, I think it was our first practice type in the Johns matter, His Honour said something about, yes, of course, and when we get the witness in, we're going to need to close the court. That's because the evidence that was about to be given was sensitive material, and they didn't want anybody who wasn't absolutely necessary in the courtroom to hear that evidence. Because, of course, we want to minimise the traumatic impact that giving this evidence has potentially upon the complainant. So I just want to show you what happens when the court is closed like that. Say, for example, we have up here His Honour saying, okay, we're going to get the witness in now. I will now ask my tip staff to close the court. Now that means that at this point, the person giving evidence is either going to physically come into the court, but more likely is going to appear via video link. What we need to do as typists is we need to come into the VGRS Word Macros ribbon and over to Court Events. And what we need to click is Start in Camera. Now we've been talking about closed court. In camera is exactly the same thing. And I'll just explain in a second why. There we go. So we've got proceedings in camera. That macro starts. You can see it says in camera hearing follows, and you just start typing the evidence in here. So when they're sworn in, you'd come and you'd grab your macro and just go from there. And when you get to the end of that witness's evidence, the court then opens, if you like. So you would come back up at the very end of that person's evidence, the court events, and you would chuck in end in camera. There we go. These are incredibly important to remember in the text when we're typing, because when the matter is merged, when an in-camera proceeding starts or a closed court proceeding starts, it will start on a separate page. And it is also very important because it appears in the footers in the merge. So in the finalised transcript down the bottom, instead of saying discussion or witness evidence examination, it will say in camera witness evidence, or whatever the case may be. Now I'll just draw your attention in this final minute to the section of the manual for closed court. It is at page 70 of the manual, and you can see here that closed court and in camera mean exactly the same thing. In camera is the Latin. Sometimes you might also hear in curia, which means in the court. In camera means in a chamber in Latin. So what happens is that generally the tip staff will walk outside of the courtroom and put a notice on the door saying that nobody is allowed to come in during this witness's evidence. Necessary to the proceedings. So usually you'll just be left with the judge, the person giving the evidence, the lawyers involved in the case, sometimes a police informant, and everybody else has to leave the courtroom. Also the tip staff and the associates, a general courtroom. That's just a very brief introduction to closed court and in camera, and we can come back to that as we go on. I do note, though, that the time is 12:29. We have 1 minute for any questions. Does anyone have just any preliminary questions on that at this stage? Not by the looks of things. Okay, fantastic. In that case, please feel free to go to lunch now. Just as we've done the other days, I might ask you to come back at 1:30, and you can, of course, join the meeting using the link that I sent you yesterday to the Blue Jeans meeting for the afternoon. Any questions or concerns, feel free to send through an email or a Spark. I might be a bit delayed on Spark because I'm going to go to lunch as well. But all going according to plan, I'll see you for this afternoon when we're going to start talking a little bit about what happens when we have witness evidence given through an interpreter. So witness evidence in a foreign language that is then interpreted by an interpreter. Fantastic. Thank you all so much, and I'll see you in about an hour.
Thanks, bye.
Thanks.
Thanks,
Bye. Bye. See you later.